Morning, Mr. Black.
Morning. Pleasure to be here.
Mr. Black, you filed various motions to dismiss the driving with suspended license third degree against you. I've read all of it. We are getting kind of late in the morning here. Is there anything you'd like to say that is different from or that you'd like to highlight from the motions that you filed?
Well, first, may I ask the court to identify yourself and the prosecutor?
Certainly. I'm Court Commissioner Jacob Stillwell.
Uh-huh.
And prosecutor today is Ford Libby, Rule 9, supervised by Rosemary Fitzgerald.
Okay. Yes. When the officer stopped me, he asked me for paperwork and simply accused me of a paperwork violation. He asked for three things: license, proof of insurance, and registration. Anyone who's engaged in a potentially hazardous activity like operating a motor vehicle has to have his paperwork in order, especially insurance, because he can cause damage with his car. Excuse me. Same thing is true with yourself, because being a judge is a potentially hazardous occupation because it involves violence. No one can be put in a jail cell without unwanted touching, and a lot of damage can come to people if a judge does something wrong. And as a person who has been through a family court and witnessed how unprofessional and out of control the judiciary is here in Washington, and I think you know that the reputation of the legal system in Washington is very bad. I mean, even at one point, the federal government had to come in and supervise and babysit the police because they weren't being controlled.
So I'm going to just try to frame what I'm looking for. Because again, I did read what you briefed, and so maybe it would be helpful if I outline my thinking here.
Before this hearing even begins, understand this. This is not a routine traffic case. What you're about to watch is a courtroom collision between a self-represented defendant who believes the entire legal system has no authority over him, and a court commissioner who has tried to keep the proceeding on track while the clock is ticking. The charge itself is simple on paper: driving with a suspended license. But the strategy here? Anything but simple. Instead of arguing the facts of the stop, Leonard Black launches into a sweeping challenge of jurisdiction, authority, oaths of office, and bonding requirements, essentially putting the court itself on trial.
I'll give you a chance to respond. I'll give the chance for the city of Tumwater as well to weigh in here. But let me just kind of start where I'm at. That sounds good to you.
Sure.
Okay. All right, because I know a lot of your arguments are sort of based on sort of overall authority to enforce these laws against you. So I'll sort of start there. The Revised Code of Washington, which is the state legal code that is applicable here to criminal offenses related to driver's license, it provides at RCW 4620-342 that it's unlawful for anyone to drive a motor vehicle in the state while the person has a suspended or revoked driver's license. The allegations against you is that you were driving a motor vehicle on a public road with a suspended driver's license. Now, those are still allegations against you. That hasn't been proven. But the city of Tumwater is within its authority to pursue that prosecution because you were allegedly driving a car with a suspended license. And so I know you've raised a number of concerns around that. One of them being, right to travel. You do have the right to travel. You don't have a right in any particular mode of travel. So driving a car does trigger certain legal requirements.
Excuse me. I've been in this court already, I think this is the fifth time, and each time I've heard the judge make the arguments that the prosecutor is supposed to make. In other words, the judge has been prosecuting. May I get back on track, because I was making a point. I was heading toward a point when you asked to interject.
Sure.
Okay, so we need to take care of some preliminary matters first. Just as I had to produce paperwork when an officer saw me, what he believed to be engaged in privileged activity, you need your paperwork in order too, and I just need to verify that your paperwork is in order. I am eager to argue my motions, and I'm eager to hear the prosecutor's response, but first we need to know if you have your license to operate, which is your oath of office. That's analogous to a driver's license. It's because nobody has a right to be a judge. It's a privilege. And also your bond, your official bond.
Right here is where things start to shift. Instead of addressing the motion to dismiss directly, the defendant pivots immediately into a broader philosophical argument, comparing driving to judging as hazardous activities and suggesting judges should be subjected to the same paperwork demands as motorists. This is a classic tactic, expanding the scope of the discussion so widely that the original charge becomes secondary. Notice how the court commissioner attempts to acknowledge the argument while gently steering things back toward relevance. But that effort doesn't land.
And through a surety company is analogous to an insurance for a driver. Because if I'm injured in the course of these proceedings, I need to know that I can be compensated. So
you are welcome to file a public records request asking for any documentation around my authority as the court commissioner or anyone else in the...
Right, and I couldn't do that because I didn't know who would appear today as a judge. I mean, I asked before and I couldn't get a clear answer. Also, your bond is supposed to be filed with the county clerk. And with your permission, I mean, I want to make it easy for you. Don't want to make you produce it for me. I could go around the corner to the same building here and verify that your bond is filed with sufficient sureties.
So we're not going to do that today for relevancy purposes here, because what's relevant here is not anything related to me. It's related to allegations against you driving.
It absolutely is relevant to you because it's all about whether you have jurisdiction, and you don't have jurisdiction without your oath of office timely filed and a bond with sufficient sureties. And I have a pocket brief here that I'll give you the court and a copy to the prosecutor to show you.
I'm going to stop you again, and I don't mean to interrupt here, but you have the opportunity to look at those documents. If you're able to find documents in any way, indicating that we don't have the proper authority or to operate as a court in this case, you're welcome to get those documents and present them. But we're not, during the course of the prosecution, going to chase down every indication without any supported evidence that something's amiss here. So if you have something through a public records request, you're able to bring it. But we're not going to chase down all of those arguments as they pop up. We're not going to play whack-a-mole necessarily with arguments being made without evidence.
So if I told the officer who stopped me that I have a driver's license, I have insurance, trust me, it's your job to go look for it, not mine to produce it, what do you think he would have done?
Well, I don't know. I wasn't there.
Well, we all know what he would have done. He would have said, that don't cut it.
This is a turning point. When a defendant accuses a judge of making the prosecutor's arguments, he's crossing a line that dramatically escalates tension. This claim strikes at the heart of judicial neutrality, and it's a common refrain in sovereign-style defenses. The implication is serious, that the court is no longer impartial. Watch how the commissioner responds, not emotionally, but structurally, by emphasizing process, authority, and statutory grounding. This is a judge asserting control without raising their voice. At the same time, the defendant doubles down, insisting the court must first prove its own legitimacy before proceeding.
So these are all comments that you made in your briefing. So I'm going to, again, remind you, I've read those arguments that you made.
I'm going to give a copy of my pocket brief showing that the judge and prosecutor both require bonding and insurance. And with your permission...
And if you have evidence that there hasn't been proper bonding, you can certainly recommend.
Well, that's my evidence, my testimony here.
Right. Well, you're not alleging it hasn't happened.
I am alleging it hasn't happened.
Whatever.
I am alleging that.
Whatever.
With your permission, I'll give the court a copy of the pocket brief I just gave to the prosecutor.
Sure. But then I'm going to turn it over to the prosecutor to have an opportunity to respond.
Isn't it my turn to present my motions?
Yes, and you have.
No, I have not.
You have. You've provided written motions. You've been given some time to sort of summarize what your arguments are here. So we also want to hear from both sides.
I need to make a statement for the record so the appellate court can understand.
Well, it's 11:33. You got till 11:40. And I'm going to turn it over to the city time.
Well, if the prosecutor wants you to take 3 months out of my life, you have to give me enough time because the taxpayers are going to pay for this. You see, when the officer first stopped me, it was mistakenly thought that I would pay the $66 fine or whatever, how much it is. And what's going to happen is the opposite. The plaintiff is going to house me, clothe me, feed me, take care of all my needs, medical needs and everything. And I'll get to watch television. I love to watch television. And I love to kick back and relax. And that's what's ultimately going to happen. But we're going to go through due process first. I won't be denied due process. So every district judge, this is RCW 3.34.080, every district judge pro tempore, and district court commissioner shall, before entering upon the duties of office, take an oath to support the Constitution of the United States and the Constitution of the State of Washington. And as far as bonds, every judge of a municipal court, before entering upon the duties of office, shall take and subscribe the following oath or affirmation. I do so.
At this stage, the hearing enters what many legal professionals recognize as the paperwork loop. The defendant repeatedly demands proof of the judge's oath and bond, treating their absence or his inability to locate them as prima facie evidence of no jurisdiction. The court makes something very clear here. If you believe such evidence exists, you must bring it properly through motions and records requests, not spontaneous demands during a hearing. This matters because courts operate on procedure, not on-the-spot investigations.
Solemnly swear or affirm that I will support the Constitution of the United States and the Constitution of the State of Washington. The judge shall also give such bonds to the state and city for the faithful performance of the judge's duties as may be by law, ordinance, or directed. The prosecutor's bond, every county official before he or enters upon the duties of his or her office shall furnish a bond condition that he will faithfully perform the duties of his or her office. Prosecuting attorney shall file it in the amount of $5,000 with sureties to be approved by the proper county legislative authority. Tumwater police officers also have to have a bond, and that's RCW 35A.12.080. As far as, so it's very, very important. It's not just a joke or something that's not important. It's very important that you have an oath of office on file, because from what I've observed in this court and many, many courts throughout the last 40 years living in this state, that judges hate to follow the Constitution. They despise it. So I need to ascertain that you have a timely filed oath of office. Now, I did make a public disclosure request for all the judges that might be operating in this court, and I have them here. I want to make sure your name is on it. I have an oath of office for a John Tunheim. It's not you, right?
I remind you to, you've got till 11:40. It's 11:36.
What if it takes longer?
Because sir, I'm telling you again, I've read what you've written, and you're frankly not making arguments that are relevant to your prosecution. You're allowed to speak, but if you have evidence and if you have evidence there that you wanted to present to the court, you should look at it beforehand and then make an allegation.
I did.
Well, you're reading through the response to your Public Records Act.
You said I should make a public disclosure request for your oath of office and bond, and that's what I've done. And here I'm going through it.
Right, you should go through it before the hearing.
Well, I didn't know who you were until I just sat down here.
Now the clock becomes a weapon. As time runs out, the defendant ramps up his monologue, invoking taxpayers, incarceration, and even personal comfort in jail as rhetorical devices. This isn't accidental. Long, winding statements can be a strategy to force errors, create appeal points, or provoke reactions. But notice how the court stays focused on the calendar. Courts run on schedules, and exceeding them doesn't strengthen an argument. It weakens it. This moment highlights a hard truth. Due process includes reasonable limits. Being allowed to speak does not mean unlimited airtime.
I didn't know who the prosecutor was.
Your Honor, I don't want to belabor the point, but just to make sure that we're being as effective as possible here, this just falls outside of the scope of today's hearing.
I know.
No, it does not, because my brief addresses the importance of obeying the Constitution of the United States and the state of
And
Washington.
I can tell you, I have my oath of office. I took it a couple of weeks ago. Granted, I'm newer here, but I took it in this very room.
Well, I could not find it unless it's here, because I was given all the oaths of every judge that could possibly be working here. That's what I requested. I also have an oath of office for, it's John Tinham again. He gave me a few.
We are
As far as
gonna turn it over to
bonds-
1140, just so you know.
As far as bonds, Joel L. Lapierre is supposed to have a bond. That's not you though, right? What is your bonding number?
I don't know. Off the top of my head.
Okay, so before we can proceed, we have to take care of this preliminary matter.
That's not true.
Well,
You are welcome to bring evidence that I'm not a correct judicial officer for this, but again, we're not going to play whack-a-mole.
well, you're supposed to prove it to me,
That's
just
not
like I was
the case.
supposed to prove it to the officer that stopped me, that my paperwork was in order before engaging in a privileged activity.
I certainly believe that, but that's not the law.
You don't, can you cite the law then?
No, you're asking me to cite a law that doesn't exist. A judicial officer does not need to present their bonding number to every defendant.
But you need to have a bonding number, and we've determined that you don't. I requested the bonding information and the oaths of office of every judicial officer that could be working in this court, and they gave it to me all here, but your name doesn't appear to be on it.
Well,
That's prima facie evidence that you don't have an oath of office or bond.
okay, well, then you can file a motion on that specific question if you'd like, but you've got 2 more minutes for this morning.
Okay, I'd like to file that motion right now.
You don't have it. You got to go file a motion.
I can make a verbal motion. I can make it orally. Do you want me to find the RCW, the statute that allows me to make it orally?
Sure, and then you can go and you'd have to, well, I can't give you legal advice, but.
You gave me a lot of legal advice
I'm
today.
explaining what the law is.
The prosecutor said nary a word.
You got one more, well, because we've been giving you a chance to speak, and you've got 1 more minute before we're turning it over.
This is a critical clarification. The commissioner explicitly states that he took his oath of office recently in the same courtroom. That directly undercuts the defendant's central claim. But instead of reassessing, the defendant rejects the explanation because it doesn't align with his documents. This moment exposes a flaw in his logic, treating incomplete records as proof of non-existence. The judge responds by outlining the correct remedy, file a motion, present evidence, follow procedure. Importantly, the court denies the oral motion on jurisdiction, not dismissively, but with an invitation to pursue it properly. This is the legal system functioning as designed.
Well, I have to determine whether we have jurisdiction here.
No, that's not up to you.
Well, it's up to you, but you're not making a decision on it.
Because we do have jurisdiction. I'm telling you I have an oath of office.
But that's not enough. Me telling the police officer I have a driver's license is not enough.
The allegations that you did not have a valid driver's license.
Yeah, a surgeon telling his licensing authority, I have a license, without proving it is not enough. We have prima facie evidence here that you don't have an oath of office or bonding. And the Constitution, you say you have an oath of office? Well, that means you swore to uphold the Constitution. And the Constitution requires you to have an oath of office timely filed. And RCW Title 42 says if you don't have it timely filed, you're not lawfully in office. That means that you can't preside over this hearing.
And to the extent you want an answer right now, I'm denying that motion. If you want to file something in writing that goes into that in more detail and provides some kind of evidence that I don't have authority, you're able to do that. I don't know when you made your public records request. It might have been before I took my oath of office, but we're out of time for your arguments.
How do you spell your name?
S-T-I-L-L
S-T-I-L-L
W-E
W-E
L-L.
L-L.
First name Jacob with a C.
Okay. I'm going to not participate in an unlawful hearing. So I'm going to go over to the clerk's office and try to get your oath of office and bond. And if they have it, I'll be back here and let's proceed. I'm actually eager to do so.
Well, we're going to have to file a motion. We're not going to probably be here anymore when you come back. We close up at noon.
You don't operate after lunchtime at all?
No, the calendar is going to end at noon. So if you find something, you can file a motion, but we're not going to stay open just so you can go do your driver's license.
Okay, well, I came here at 9 o'clock because I thought things would start then, and I had to endure watching all this.
So we're out of time at this point.
So that's what I'm going to do, because I'm not going to participate in an unfair hearing where there's no jurisdiction. I will file another motion.
Final comments here, because we got to move on.
When the defendant announces he will not participate, the dynamics shift again. Walking out of a hearing is a powerful visual, but legally, it carries consequences. The court doesn't chase him, doesn't argue. It simply explains next steps. That restraint is intentional. Courts don't operate on ultimatums. The recusal request at the end feels less like a legal maneuver and more like a symbolic final strike. And yet, the judge acknowledges it calmly, signaling that the system will move forward regardless. This moment underscores a key lesson. Refusing to engage with process doesn't invalidate it.
My final comments are this. We're going to assume that you don't have an oath of office timely filed or bonding, so you can't proceed over this hearing.
You can
It's
go get
simple.
evidence of that. You can come back, but until then, we're going to, unless the prosecutor has anything to say.
Okay, so then since I object,
Sir, I'm moving it over to the prosecutor.
so since I'm wait, I have a right to make my motions. I have a right to argue my motions.
Sure.
I brought this hearing.
I understand.
Not the
We're going to
prosecutor.
move on.
I brought this hearing, not the prosecutor.
We're going to move on.
So I'm going to ask you to recuse yourself since you're not well.
All right, well, if there's been a request for recusal, perhaps I won't be here at the next hearing, but that's going to be it for today, okay? Free to go. Well, sir, we're also here set for trial confirmation. You have a jury trial set.
I haven't even entered the plea yet.
Well, you don't have to. I mean, the state is moving forward. Probable cause has been found. You've elected to represent yourself against.
I am myself. I don't represent myself. I am myself.
Well, are you ready to proceed to trial on November 17th?
First, I have to be advised of the nature and cause of action and enter a plea. And I have to verify that the judge, which keeps rotating, is lawfully in office. I mean, I'm not trying to throw monkey wrenches in this or anything or give you a hard time. I'm just trying to require due process.
You were arraigned on June 26, 2023. Determination of probable cause was found.
Your Honor, just to,
Well, you said I'm free to leave, and you're not lawfully in office, so I'm going to leave.
well, Your Honor, if the defendant's going to walk out.
This hearing ultimately wasn't about a suspended license. It was about control, relevance, and procedure. The court repeatedly explained the law, the limits of the hearing, and the correct path forward. The defendant, meanwhile, chose confrontation over compliance, insisting the court prove itself rather than addressing the charge before him. Whether you agree with his philosophy or not, the outcome was shaped by one simple fact. Courts run on evidence and process, not personal theories of authority.